the impugned order. At
Page
69.
69.
Yes.
Yes.
Your Worship, if I may read this order, this is dated 29 August 2025. Whereas a written examination for recruitment to the post of sericulture demonstrator was held on 8th and 9th April 2025, and on recommendation of DPC dated 7th of May 2025, appointment to 4 posts of sericulture demonstrator under sericulture department was issued white order dated 9th of May 2025. Whereas a written complaint was lodged by candidate regarding alleged irregularities in the recruitment process for the said post. And whereas an inquiry committee was constituted to investigate the recruitment process, white notification number so-and-so dated 14 May 2025, inquiry committee found certain omissions on the part of the concerned invigilators and submitted its report on 24th of June 2025. Inquiry recommended to reconduct written examination on paper 1 and paper 2. The report was accepted by the competent authority. Whereas Law and Judicial Department was consulted on the matter, wherein the department is advised that the entire process of selection for the recruitment can be set aside as purity of process must be given precedence over inconvenience. Now, therefore, on the basis of the report and recommendation of inquiry committee, and as per advice of Law and Judicial Department, competent authority hereby set aside the entire selection process of recruitment to 4 posts of sericulture demonstrator and ordered to conduct recruitment afresh, and accordingly appointment order dated 9 May 2025 stands cancelled. So, if I may take your lordship to para 3, whereas an inquiry committee was constituted to investigate the recruitment process, white notification dated 14 May 2025, inquiry committee found certain omissions on the part of the concerned invigilators. Your Worship, in fact, there is no finding against the candidates that they had indulged in cheating or anything like that. It is just that some omissions were found on the part of the concerned invigilators. Now, if I may take your lordship to the report submitted by the committee. The report submitted by the committee is, it starts from page 50, annexure 12. The relevant portion is at page 60. Page 60.
Yes.
Roman 5, para Roman 5, findings. Inquiry committee, after thorough investigation with available
60 or 60 or 16?
60.
60, yeah. It starts from para 32 of the report.
Sorry, page 66. I'm sorry, page 66. Page 66, the findings of the inquiry committee.
Yes.
Para 5, Roman 5.
Yeah.
Inquiry committee, after thorough investigation within available information and sources, concluded the investigation with the following facts and findings. Inquiry revealed that 3 candidates, Angela Alvin Moy, roll number 2, Wanal Sung, roll number 34, Lalram Sang, roll number 12, confessed that they carried mobile phone inside the examination hall in the first day of examination, which was not permitted and violates instructions to the candidates, point E in the admit card issued to the candidates. It appears that the official, not attempting effectively to prevent the candidates from carrying mobile phone inside the examination hall, even though one candidate, Walal Nienga, roll number 37, stood up and verbally complained and requested to conduct physical checking. This is a serious lapse and error committed by the conducting officials, which is violation of para 20, subclause 6 of the Mizoram Direct Recruit Conduct of Examination Guidelines 2018. Number 2, one candidate, Manlal Nienga, submitted a written complaint to inquire to conduct of paper 1 examination to the director on 11 April 25. The matter was not brought to the notice of the administrative department, which appears to be a serious lapse in the part of the directorate. As withdrawal of the case by complainant neither influenced nor satisfied other candidates. Further, it flares up suspicious and resort to submit complaint to the MZP and eventually to the department. So the findings of the inquiry committee is that 3 candidates had taken mobile phones and none of these 3 candidates were recommended or appointed. The petitioners, there is no finding against the petitioners. And they are blaming the officials for not conducting the examination effectively. And one candidate had submitted a complaint in writing, but which was subsequently withdrawn. So now the Honorable Supreme Court, in a number of cases, has held that when the tainted candidates can be segregated, the question of setting aside the entire selection process does not rise. So the only finding of the inquiry committee is that 3 candidates had taken mobile phones into the examination hall, and apart from that, which was not, and the candidates before entering the examination hall were not frisked properly, which is a violation of the guidelines. And that one candidate had submitted a written complaint to the directorate, which was not reported by the directorate to the secretariat. But subsequently, even that complaint was withdrawn.
They found 3 candidates, but that was after the exam was over.
Yes.
In their inquiry, they found 3 candidates. There could have been more. Who knows?
Out of 30,
even you might have been carrying a mobile phone.
If your Lordship will see, the inquiry committee had taken the statement of 35 candidates out of 38.
Yeah.
And as per the answers given by the candidates, the inquiry committee came to a specific finding that only 3 candidates had carried phones inside. And
That is the 3 candidates they found.
yes.
How did they find all the candidates?
No, that is why 38 candidates appeared for the examination.
This doesn't happen to be a case where the shaft MD is separated from the grain.
Your Worship,
Anyway, what's to be done at this stage?
at this stage, my submission, Your Worship, is that since the tainted candidates can be segregated, the question of cancelling the
Okay,
entire
we'll issue a
session,
notice at this stage only.
and Your Worship, there's a prayer for suspension of the selection process being reconducted. As per the order,
We'll turn the clock back if necessary. Issue notice. Steps within 3 days by registered post ID. Extra copies be served under the council.
Your Worship, just some observation that any process resulting in
Yes.
appointment will be subject to the outcome of writ petition.
Fresh selection process will be subject to outcome of the instant writ petition.
I'm okay.
Yes.
Your Worship, notice
1 to 5.
Yeah. 1 to 5.
Yes, Mala. State response.
For mission, item 2.
Four weeks.
My Lord, I'm here on behalf of Miss Mary for respondent number 3 and 5, and she's on leave today. If this matter may be taken up after 3 weeks.
On the player of learned counsel appearing on behalf of respondents number
3 and 5.
5, list the matter after 3 weeks.
Item 3.
your affidavit is still awaited.
My Lord, I'm here on behalf of Miss Del Nunpui for the state respondent, and if time may be given to file affidavit. If further time will be given to file an affidavit.
But you're going to file affidavit.
Yes, my lord. 2 weeks time, my lord.
Yes, Malhotra,
It's okay. This is the second time it's come up.
on the prayer of learned counsel appearing for respondent number
All the respondents.
1 to 6.
1 to 6. Further 2 weeks time is granted to file counter affidavit. This is the matter after 2 weeks.
Item 4.
My Lord, the Honorable Supreme Court has stated the operation of the judgment and order. So if the outcome may be awaited. This order was passed by the Honorable Supreme Court on 17/04/2025.
It is submitted that the judgment and order in respect of which the present contempt petition has arisen has been stayed by the Honorable Supreme Court by its order dated.
17/04/2025.
Okay. Hence, list the matter after 6 weeks for orders.
Item 5.
May I please, Your Lordship, this is an application for modification or relaxation of bail bond and condition of sureties imposed upon the petitioner by the Court of Judge, Special Court Indian PS.
Are you ready with the full address?
Yes, Your Lordship, we have submitted the proof of address by means of Aadhaar card. We had filed additional affidavit.
Where is that?
Last Tuesday.
State, what the state has to say about modification of the bail conditions?
Lordship, both the petitioners were arrested by the Directorate of Intelligence officers in connection with the huge recovery of the heroin, which is 1,456 grams, which is a commercial quantity, Lordship, and from the special cavity of the Maruti Swift Desire, driven by both the accused. Lordship. And the reason for their release was on the ground that the grounds of arrest was not intimated in writing. That is the only ground considered by the learned trial court, Lordship. And regarding the bail condition imposed by the learned trial court, Lordship, from our side it is not too harsh, and since those conditions are very much necessary in order to attend those accused to the court. And Lordship, understand that the coordinate bench of this honorable court had already reduced in the other cases, and that reduce was from the permanent resident of LDC, it was reduced to any government servant. So I think that maybe
What do you have in other case?
in other case, Lordship.
Do
That
you have any copy of such order?
I think they
We have, Your Lordship.
Lordship, the operative is at paragraph number 15.
So in this case, the requirement of government servant has been removed.
Not remove, Your Lordship, which is at page 15.
The rank of LD.
This court finds it fit that the second condition may be modified to the extent that one surety would be okay. Any government servant.
Lordship, yes.
Any government servant.
Any government servant. Earlier it was not below the rank of LDC.
Okay. And the other surety may be a local resident of the state instead of Aizol only. Okay. So you are agreeable to this?
Yes, Your Lordship.
Okay. So you pass similar order.
Lordship, yes.
Okay. This previous order is there here. Similar order. I'll cross check it.
For orders, item 6.
Lordship, we have received the paper book. The matter can be listed for hearing.
It is submitted on behalf of the petitioner that the paper book has been prepared and furnished
Both the
to,
parties.
to all parties. Hence, list the matter for hearing in usual course.
Item 7.
My Lord, according to the office note, ID card has not been returned in respect of respondent number 2. And in respect of respondent number 1, who is the claimant.
It says no such person in
Yes.
this address.
Yes, however, my Lord, that address and that person who have given based on the claim petition submitted before the learned Employees Compensation Commissioner. So, if newspaper publication in respect of respondent number 1 may be allowed now.
Where is the address?
address is given as Lai Klang.
Respondent 1.
Yes, my lord. She is the claimant.
Johnson Choi, daughter of Balsim Leona, Aru, Lai Putlang. Aizo. Is that enough?
My lord.
Resident of Lai Putlang.
Yes. That, if your lordship could,
Is it such a small place?
if your lordship could kindly come to page number 16 of the main MAF, my lord. The address in her petition, in her complaint, was given as such, my lord.
She may be giving that, but actually,
So the appellant being the insurance company, the appellant has no other way of finding out the exact address other than what has been stated in her claim petition.
is there any stay order?
None, my lord. We have filed a different application, my lord, IA.
Mm-hmm.
We have filed a separate IA for stay, and the instant IA 107 is for condemnation of 235 days delay.
So the amount has not been disbursed as yet.
No, my lord.
So even after 200 odd days, they have not come seeking
For execution.
payment.
No, my lord. None.
You must be knowing the lawyers who represented them.
Yes, ma'am. Yes, we are aware of the lawyer who represented the respondent body before the employees' compensation.
So why can't you ask if they can appear?
My lord, we will do that. We will do
Okay, instead of going to all this newspaper and all, let's adjourn this for 2 weeks. You find out the
My lord.
lawyers and have them represented. ID card in respect of respondent number 2 is awaited. Notice to respondent number 1 has been returned unserved with postal note that no such person is available at the given address, and that address he left on 26/8/2025. Learned counsel for the applicant's insurance company submits that he will make an inquiry through the learned counsel who had represented the claimants at the trial, hence release the matter after 4 weeks.
Item 9.
Lordship, this item has been listed with an IA 177 of 2025, Your Lordship. However, Your Lordship, this is an application for the impeachment of the new incumbent. However, Your Lordship, I have found some discrepancy with the incumbent. So Your Lordship may kindly allow me to withdraw?
Die
Yes, Your Lordship. With
on the
liberty.
prayer of learned counsel for the applicant, the IA civil number 177 2025 is allowed to be withdrawn. I stands disposed of
Your
accordingly.
Lordship, with liberty to file fresh if
With
needed.
liberty to submit fresh application.
Much obliged.
Part 2, item 10.